This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
And I appear for the respondent writ petitioner.
But this is an appeal by the state.
Well, I have only one sentence to say, that this is a second round of litigations. In the first round of litigations, the state questioned that High Court doesn't have jurisdictions. It came up to your Lordship's division bench. The Lordships negated it. Now, this time, this is on merit. The writ petition has been allowed. And urgency in the matter is, whole matter is only for 1 year, starting from May 2025, and it will expire in 25-26. Now, I'm the anesthesiologist. So starting from May itself, I am at home. I'm not able to be in the operation room. So effectively, I will lose all my aptitude because it's a 1 year bond.
Yes, Mr. Ask your junior to effect the corrections. The corrections. Yes.
Number different. Only Millard, a short recollection of facts, since your Lordships were pleased to Millard consider this matter at the interim stage. But here, Millard,
The maintainability issue.
on the maintainability issue, Millard, on the maintainability issue, Millard, my submission was that this is rendering public service
So go to the
to
tribunal.
the tribunal. Millard, I did not succeed because your Lordships were of the view that no, it does not amount to any public service. Here, Millard, now, Millard, the final judgment has come. Astonishingly, all the principles of public employment has been applied. All the principles of public employment. I'll take it as my last point. But primarily, Millard, the question, Millard, which has been framed by his Lordship, Millard, your Lordship will find, Millard, at paragraph 1. The doctors, other than the government-sponsored in-service doctors, after completing postgraduate and postdoctoral courses from the state medical teaching institutions, as per indemnity bond executed by them at the time of admission, are obliged to serve the state by working in different government hospitals as senior residents for a certain period of time. The Department of Health and Family Welfare, Government of West Bengal, in order to get such service of the said class of doctors, video order number so-and-so, has prescribed a standard operating procedure in SOP in short. Now the issue. The issue falls for consideration in the present writ petition is whether the department is bound to follow the procedure prescribed under the SOP to deploy and or engage the said SRs during the said bond period. Now, this is, Millard, the question which has been framed by his Lordship. Now, Millard, the undisputed facts, Millard, I skip over Millard, paragraphs 2, 3.
No, Mr. Dotto, when was the appointment given? That the list which you challenged, list which was challenged
by them, yes.
That was of by that he was placed at a particular place in Raiganj.
In Raiganj, right.
His contention was, I must be appointed in RG Court.
RG Court, because at the time of counseling, I had opted for RG Court.
Now, that was in
27th May. Counseling notices on, yes, 2025.
So, Mr. Dotto, you allow him to join. We will say it will abide by, we will decide the appeal.
Then it becomes academic. But if I allow him to join, it becomes academic.
He's out of any sort of engagement.
No.
He has senior resident, government bond was
The
there.
question is where will he join?
No, we will fix an immediate date, but you allow him to join. Otherwise, the entire tenure goes, Mr. Dutt.
No, tenure has not started. If he joins tomorrow, his tenure starts from tomorrow. If he joins after 1 month, his tenure starts from after 1 month. So therefore,
Oh, I see.
Therefore,
It
yes.
will continue for a period
yes,
of.
yes, of course. That is the bond. He has to serve for a period of 1 year.
So where he is appointed now?
But he was posted at Raiganj Medical College and Hospital. He has not joined.
Now, today, suppose if the appeal succeeds, in that case, he has to.
Join at Raiganj and Millard work for 1 year. If the appeal does not succeed, he will join at RG Court and then Millard from the date of joining 1 year.
There is no scope for interim order, Mr. Dotto.
Well, I'll face contempt then. Millard.
Contempt High Court.
Well, I have to file because of this.
File.
No, I haven't filed because it is the first day. Well, out of is the point is only one. 871 doctors.
No,
Who
we
have-
will hear you, Mr.
Well, nothing on merit, nothing on merit. Just to understand what is the matter. 871 doctors. For all of them, one process that counseling merit.
My learned friend.
And
with
for
due
me,
respect,
For
I
me,
don't.
it's a different process.
I don't usually disturb.
It is
Because
a
he has
normal-
given up his case of malafide before the learned single
no,
judge.
no.
Why is he bringing
What
in that
we are-
out
what
of
we are-
800 he has been?
I am not on merit at all. All I am saying, this is not a case of engagement or appointment. It is a case where government circular has been followed for all the candidates minus me.
Let us see, Millard.
On merit, I am supposed to be at RG Court.
But at paragraph 1, whether the department is bound to follow the procedure prescribed by the said SOP to deploy and or engage the SR during the bond period.
Now, first tell us the facts which were there. Main facts in the writ petition. You have shown us the prayer portion.
Yes,
They were challenging a notification of 27th May.
right.
Where is that, Mr. Dutt?
Yes. But the 27th May notification, your lordship will find at page 98.
Yes, what is this?
Where this is Millard, the posting, deployment, whatever is the appropriate term. Please take the first line. The undersigned is directed by order of the governor by order of the governor to say that the governor is pleased to deploy 871 non-sponsored postgraduate doctors mentioned in the annexure to this notification at column B of the West Bengal University of Health Sciences having registration, etc. But the rest are not required for the present. But my learned friend's client's name is at page 100, serial number 24.
Yes.
Now, Millard,
He was placed in Raiganj.
it was placed in Raiganj and he had opted for
RG Court.
RG Court during counseling.
So, where is that decision in negation of his option?
No, there is no decision as such, Millard, which has been communicated. Millard, these are, Millard, how, Millard, deployments are made.
All right.
Now, Millard, please take, Millard, the counseling notice, which your lordship would find, Millard, at page 71. But it starts at page 70.
Yes. 70. Yes.
But this is 6th of March.
Oh, the printed number. See,
Printed number. Yes, Millard, the printed number. not the handwritten one. 70.
Yes, 70 is
The counseling for the engagement of senior residents who have passed out so and presently under indemnity bond contract at different medical college hospitals so under the department of so following the extent provisions will be held on so schedule. Now the most important part on which much emphasis has been laid is at page 71. The candidates The candidate should report to the venue at least half an hour before the initiation of the session allotted for the disciplines concerned. The next sentence is what we need to dilate on. The choice once made during counseling will be final and cannot be changed under any circumstances. This sentence, Millard, appears to be one of the foundational stones for coming to the conclusion by the learned single judge that if somebody exercises choice at college A or hospital A, he cannot be posted at hospital B. This is one of those.
yes.
Then, Millard, if your lordships may kindly take, Millard, the SOP.
Page
Yes. 127. But the SOP, Millard, my lords will find, Millard, at page 127, printed page.
Page 127.
But in between, Millard, one page, Millard, I've missed, Millard. Kindly permit me to place, Millard, page number 97.
Page 97.
Yes, Millard, I'm so sorry, Millard. Now, Millard, after they go to counseling and after the choice, Millard, this is a self-declaration given. But this, your lordships had the pleasure to look, Millard, at the previous round, where I'll not read in its entirety. Please take, Millard, the second last line, dated 21st of March 2025, from the date of physical joining to the place mentioned above. But above means, Millard, RG Kaur, if offered to me.
Page 97. To hereby opt to be engaged if offered.
Yes.
So on this basis, you say that page 98.
Yes.
No.
97, Millard.
This ought to have been read with the clause at page 71.
Right.
Yes.
But my submission would be the clause at page 71 binds the candidate that he or she cannot change the option once exercised.
It binds the candidate and not the state.
Yes.
Yes. So the learned single judge held against you.
Yes, on this point.
Yes.
Now, if your lordships may kindly come to Millard, the SOP, which is Millard at page 127.
Yes.
Millard, without troubling much, kindly take, Millard, paragraph 7A at page 129.
Yes. Yes.
Thereafter, well, the previous paragraphs may not be relevant. Thereafter, the directorate along with the concerned branch, will arrange for the engagement of such candidates completing the postgraduate degree at different medical college and hospital teaching institutions of the state as senior residents for initial 1 year through counseling based on merit prepared on the basis of the collected stated particulars. After completion of 1 year bond service by such candidates, with the rest I don't think would be required to trouble your lordships, Milord.
No, what are you hinting at?
Milord, Milord, please take Milord paragraph 7b, then I'll come back to 7a. The directorate, along with the concerned branch of the department, will also arrange for the engagement of such candidates completing postdoctoral courses at different medical colleges and hospitals, so and so of the state as senior resident since the beginning of the service, serving indemnity bond through counseling based on merit prepared on the basis of the collected dated particulars. Then please take 7c also. The directorate so and so along with the branch will also arrange for engagement of such candidates completing postgraduate diploma at different secondary tier hospitals and rural hospitals of the state as the senior residents since the beginning of the service in the serving indemnity bond period through counseling based on merit so and so. Now, 7a, 7b and 7c are almost perimeteria. The varying factors are, Milord, the candidates or the status of them. But, Milord, this clause has been construed and interpreted to be a clause or a condition which binds the state to post or deploy as per the choice exercised during counseling. Where, Milord, I would be respectfully trying to, Milord, impress upon your lordships that this is not a clause which has to be read as a clause binding the state to act in terms of the option.
But merit is there, Mr. Dotto.
Yes, that is kindly similar. The merit is for counseling based on merit list prepared.
No,
Through counseling, because counseling, what, as your lordships know, Milord, the most meritorious candidate is called first during the counseling, who has all the choices.
Yes.
The second most meritorious candidate is called thereafter. He or she gets all the options except one, because serial number 1 has...
So you did call him for counseling on the basis of merit.
That is over. The grievance is not that he was not called for counseling as per his merit. May I read 7a once more for your lordship's consideration. Thereafter, so and so will arrange for engagement of candidates completing such and such at different so and so places of the state as senior residents for initial 1 year through counseling based on merits. Merit list prepared on the basis of the collected particulars. Or in other words, it says that I cannot call persons for counseling as per my whims.
It has to be on the basis
on the basis of merit.
Yes.
Milord, in the second line, the expression engagement is not qualified with merit. Rather, Milord, in the 5th line, counseling is qualified with merit.
Yes.
Milord, may I be permitted to, Milord, add a few words to explain? May I add a few words over here? Thereafter, so and so will arrange for engagement of such candidates completing postgraduate degree based on merit at different hospitals. And then counseling based on merit. Then, my lord, it is a twofold action based on merit. Counseling will also be on merit. Engagement will also be on merit.
State's contention is this engagement is not saddled with merit.
Yes.
It is saddled with counseling for summoning them.
Yes.
Now, is it a case that in Raiganj you are the person whom you are sending at Arjikar is at a higher merit position than the candidate here?
No. He is higher than one of the candidates. Two of the candidates.
So he is higher than two, and he was called also for counseling.
Yes. On that he has.
And he opted for Arjikar. Now, what did the other options from the subsequent candidates who had been placed?
They got Arjikar.
They got those the other two candidates who had opted for Arjikar got it.
So how many posts were there?
In Arjikar, there are 4 posts of anesthesiologist.
So the petitioner is an anesthetist. So there were 4 posts of anesthetists. So then, Mr. Dotto, if you have allowed the less meritorious candidate who had opted for Arjikar, then what was the reason for not considering him?
Now, the reason for not considering him is that in Raiganj, my lord, there are also 4 posts.
In Raiganj also there are 4 posts of anesthetists. Very good.
2 were filled up.
2 filled up. And 2 remaining.
And he was given to Raiganj, therefore 2 plus 1, 3. If he had joined, then Raiganj would have got 3 out of 4.
Mr. Dotto, just interaction. You said that engagement is not qualified by merit. Counseling is on the basis of merit, which you have explained, it is right in all counseling. Now then, if this person was opted for Arjikar, was not given Arjikar, but the person who was less meritorious to him, he opted for Arjikar and he got it. Then why this distinction?
There, my lord, my submission was that, my lord, this SOP, my lord, cannot be elevated to the status of either a constitutional provision
or a statutory provision,
or a statutory flavor, or even an executive instruction under 162.
Then why didn't you make this provision? If you are not inclined to follow that, then why did the state make?
We are before the writ court, my lord. First, my lord, I have to, or a petitioner has to satisfy that he has a legally enforceable right. But all wrongs are not to be, my lord, rectified by the writ court. We are assuming for argument's sake that he has been wronged.
So your 2 arguments are, first argument is that on the basis of the counseling option which is as state is not bound by such option.
Right.
And the second condition you said that in explanation of the reasoning, you said that you cannot go back to the SOP and find out what had been the faults there. First, there has to be an establishment of a legally enforceable right. So, to that legally enforceable right, what is your submission?
Yes, I have made my submissions. The Honorable Court has recorded that also.
Oh,
yes. But
So
I have another ancillary submission to make, which is, my lord, evident, my lord, from page 97. Lord,
Yes.
at the declaration stage also, he was aware that he may not be offered Arjikar also. That is why, my lord, it is written,
if offered to.
if offered to him. Therefore, it may not be offered to him also. Therefore, where is the question of?
But that is the prescribed pro forma you have published.
I have done. Therefore, the prescribed pro forma itself made it clear or made them aware, whoever it is, that the choice may not be followed by posting, or the choice may not fructify into a posting.
And he was aware of that, and as such, there had been no infringement.
And there is another point to it is,
Yes. Yes, Mr. Another point is,
other aspect of the matter is assuming that some right flows from paragraph 7A, assuming for argument's sake.
paragraph 7 at
7A of the SOP.
120.
SOP. As
7A.
argument's sake.
Achha.
So please consider, my lord, whether this provision is mandatory or directory. Your lordships have held to say that it is mandatory, there has to be some consequences prescribed for non-adherence.
Yes.
Now, my lord, before going to the judgment,
Yes.
but I would like to, my lord, place 7-8 paragraphs of my affidavit in opposition before, my lord, placing the judgment. 7-8 paragraphs. Please take, my lord, page 144. No, sorry. I'm so sorry, my lord. This is part of my written notes. 136.
136.
136 is your opposition.
Yes.
Thank you. Yes.
Please take note paragraph number 14 at page 144.
Yes.
With reference to para so and so, it is denied that RG Kar Hospital, being the choice of the petitioner, was final or informed or was recorded as the departmental protocol, or that there was any corresponding declaration affirming the said allotment as alleged or at all. It is evident from the self-declaration annexed at page 59 that A, the option exercised by the petitioner is final, and B, that the petitioner cannot change such option, and C, the option is dependent upon the offer of posting to be made by him. In other words, the option is subject to the offer to be made by the state government. There is no document binding the state government to offer a posting as per the option exercised. Milord, my learned friend's client chose not to file a reply to this. No affidavit in reply was filed, and that was recorded by his lordship in a previous order that the petitioner does not wish to file any reply to this. But I am hinting at doctrine of non-traverse. The corollary is, it is an admission of the petitioner of what I have said.
Yes.
Then please take note paragraph number 15.
Yes.
The paragraph number 15, please come to the next page, that is at page 145. It starts from page 144. Please take the third line at page 145. it is submitted that the posting of the candidates is based on various factors, including but not limited to the requirement of candidates in each college involved in the process. No candidate is transferred to any college of his or choice, disregarding the actual number of senior residents required at that material juncture. It may be pertinent to mention here that there are other instances that the senior residents have been posted as per the requirement of the healthcare facility, etc., and in the interest of public service, and documents evidencing the same are annexed herewith marked with so and so. It is denied. This rest is not required. This is, my lord, another point I have taken, that deployment is need-based, not choice-based. Not denied. But the basic factual denials, my lord, I don't trouble your lordships. Then, my lord, that paragraph 15, I'm sorry, paragraph 16, please take note the fifth line in paragraph 16. It is submitted that RG Kar Medical College and Hospital has 4 posts, in which 3 have been filled up and 1 is vacant. On the other hand, Raiganj, there are 4 posts in the department and 2 posts are lying vacant. Hence, in the interest of public service, the petitioner should join, etc. Not dealt with. Then para 17. Seventh line, my lord, at para 17. He submitted that exercising option by the optee does not bind the state to post the optees at the preferred place of posting. There is no dispute that the state government has control over the deployment of the petitioner and other residents, senior residents. Therefore, the petitioner cannot compare himself with other persons in order of merit and claim for a posting at the place of choice, that is so and so. Then, skipping over one paragraph, para 19, my lord, I have spoken of no right. Para 19. And it is about
Is one.
page 147, 11th line at paragraph 19, the state government.
Yes.
The state government has the right to place any person at any point of time in public interest and in view of the compulsory service bond executed by him in terms of notification dated such and such. In this connection, a requisition made by the Raiganj Government Medical College dated for minimum number of so and so necessary to provide services is annexed such and such. It is in terms of the said requisition, the petitioner has been posted at Raiganj. It is evident that the primary objective of the notification of 31st July as read with 10th June is to serve a significant public purpose of ensuring availability of medical services and infrastructure in rural and underserved areas. This overarching objective serves as the guiding principle for the administrative decisions taken under the notification. The petitioner has voluntarily executed compulsory service bond and availed of subsidized medical education and remuneration, where the rest will are more in the nature of the purpose. Were not denied. Then please take para 21 at page 149. Where page 150, please take the last line. The order dated 16 February 2023 does not create a right to be posted at a place of posting. In the petitioner self-declaration also such and such. It's almost the same. Then at paragraph 22, we said that requirement of the college.
It should, which is the 16th February order, Mr. Dotto? Page 149, last line.
Page 127.
Oh, that is the SOP.
SOP.
Does not create an yes.
Then, my lord, the last paragraph is paragraph 22. Please take away the last 4 lines of paragraph 22. No.
Yes.
The administrative discretion in the matter of posting of senior residents, doctors, has been exercised by the respondent as per the requirement of the college concerned.
Yes.
But para 23, I thought I'll read, but that is dealing with malafides. But my learned friend's client has given up the point of malafide, therefore I don't press this paragraph for the time being. Now, my purpose of showing these paragraphs from the affidavit in opposition is that whatever case I had made out, right or wrong,
Non-traverse.
not traverse. Result is admission.
Yes.
Now, your lordships may kindly take the judgment under appeal.
Yes.
Paragraph 1, I have placed. Then paragraph 5, kindly take paragraph 5. Where this is the cause of action. Just have a look to that, Milord.
Yes. Para 5.
Paragraph 5. This is the cause of action. The petitioner is alleging that in the said list, his place of posting as SR has been altered to Raiganj by changing the choice exercised by him at the time of counseling arbitrarily. The petitioner immediately said no.
Yes.
Then, Milord, the Honorable Court, Milord, records, Milord, the submissions made on behalf of the petitioner, Milord. Primarily, Milord, the submissions are that the SOP is a standard which has been formulated by the state. Therefore, the state is bound to rigorously follow it or scrupulously follow it on the pain of invalidation. The Justice Frankfurter's principle. All these judgments which my learned friend has relied, Milord, are on those. But my learned friend submissions are noted at Milord pages. If you're looking from the memo of appeal, page 4 of the judgment, it starts and it ends at page 8 top. Then, Milord, my submissions, Milord, are noted. Whatever I've said to this court, Milord, verbally, these are all, Milord, at paragraph 7 at internal page 8 of the judgment. 8, 9, 10, non-traverse also I have said, 11, 12. Then where I distinguish the judgments of my learned friend, Milord, at page 12. Then Mr. Thor's reply, your lordships would find, Milord, from page 13, 14, 15. Now, my lord, the analysis of the court is at page 16.
Yes.
Third learned counsel, the state has sought to justify the posting of the petitioner at Raiganj by ignoring the choice exercised by him during counseling on the ground that the SOP is an administrative instruction having no force of law, least of a regulation. As such, the state is not bound to follow it as the procedure does not confer any right. Therefore, it is not enforceable. The state action is under challenge. To decide the sustainability of the challenge, at first, it is necessary to introspect the scope of judicial review to such administrative action. No doubt, the scope is very limited. The law is well settled that it is not open to the court under judicial review to examine the validity of the decision, but the court can examine the correctness of the decision-making process. The Honorable Supreme Court in the case of Keshavananda Bharati has held that in such case, the court reviews the constitutionality of an administrative action and also examines its fairness, reasonableness, and justness. We're pausing here for a moment, Pilot. My learned friend will correct me if I'm wrong, but this is a judgment not relied by any of the parties. Keshavananda Bharati, Milord, was not relied by any of the parties. I would request my learned friend to correct me if I'm wrong.
Keshavananda Bharati may not be placed by anyone. This is as good as reading the Constitution.
Yes.
Please take the next paragraph. The Honorable Supreme Court in the case of Tata Cellular versus Union of India has considered the applicability of evidence principle in judicial review. Again, we have a judgment not relied by either of the parties. Then paragraph 11, Milord.
Same principle.
Same
Decision making process.
Yes, from Tata Cellular. Then, Milord, after quotation in paragraph 11, the Honorable Supreme Court, following the same principle in case of so-and-so, has held that it is not permissible to the court to examine the validity of a decision, but the court can examine the correctness of the decision-making process. Again, Milord, subject to correction, a judgment not referred by any of the parties. But I'll come to this point later on.
Yes.
Now, please take note paragraph 12. Keeping such scope of judicial review in administrative action of the state in mind, let me now examine the issue under consideration. A plain reading of the SOP would clearly indicate that it prescribes a complete mechanism to get the service of the SRs during the bond period smoothly and without any dispute. Therefore, it is not correct to say that the said document contemplates two distinct aspects, that is counseling and posting, or the choice exercised during the counseling would not directly reflect in the posting. We are pausing here for a moment. Please recollect your Lordship's earlier decision. The entire submission was that there is no scope of posting. I lost on that point. Now we are in the second round. The decision is based on irregularity, so-called irregularity in posting. It would suffice to quote para 7a, but then para 7a is quoted. Now kindly take me to para 13. The SOP without any ambiguity prescribes that posting would be preceded by counseling based on merit. Milord, on the earlier occasion, Milord, we had dealt in extenso the difference between posting deployment. But I could not succeed in impressing upon the Honorable Single Judge as well as this Honorable Division Bench that it is in fact a posting. Be that as it may, my lord, today, my lord, the decision is made on the anvil or the principles of posting.
Yes.
The SOP without any ambiguity prescribes that posting would be preceded by counseling based on merit. Obviously, such counseling is aimed to achieve the principles of fairness and transparency, as held by the Supreme Court in Bhavna Tiwari. In the present case, the state, following the mandate of the SOP, has posted 869 out of 871 candidates in the hospital opted by them at the time of counseling, but such mandate has not been followed in the posting of the petitioner and any other and another candidate, and in doing so, the state has compromised with the merit.
Para 13 you are reading.
Para 13 minute I am reading, but I really, my lord.
Para 13.
Yes, ma'am. Para 13, my lord. Please take 1, 2, 3, 4, 5, 6, 7. Please take, my lord, the 8th line, where the middle of a sentence, and in doing so, the state has compromised with the merit. Well, I ask a question to myself, but how have I compromised with merit? Whose merit have I compromised? Have I compromised the merits of the patients?
No, his merit ranking was 24.
Yes.
He was given to Raiganj.
Yes.
The next person in 25 ranking was again placed in RG.
Right.
So you have compromised on merit.
Merit of, may I, I'm not possibly clear. Lord, in order to say,
rank 34, my brother says, rank 34 also gets,
yes.
And you negate this saying that this, we just, when the government is posting him to Raiganj, in negation, because engagement and merit position, counseling will be on the basis of merit, engagement will not be on the basis of
merit. One part of my yes. This is one part of my subject.
That has been negated by the single judge, saying that you have compromised on merit.
Yes. Now, compromising on merit can happen when? It can happen
if the engagement is qualified with merit.
That is where the interpretation of 7. But on a broader aspect, please consider, my lord, compromise on merit can happen only in case of service.
But that chapter is over, Mr.
Yes,
Dotto.
now in the principles which have been applied in the previous chapter, a different principle is being applied in the second chapter. But I do not know whether res judicata will apply or not, but the principles would apply. That res judicata applies in the 2 stages of the same proceeding. If it is not called a posting in the earlier round, it cannot be called a posting in this round. And in order to negate my action, the principles of merit.
Then is it not a long-drawn submission which you are arguing, Mr. Dotto? Because that issue has rested on the basis of the judgment of the coordinate bench, which has not gone up in appeal.
No.
So therein the dispute was pertaining to the terms deployment and posting, wherein your argument was that it is a posting, you go to the tribunal. Mr. Dhar says that no, in this case, and that Rahul Bansal or something.
Right.
But that issue, Mr. Dotto, how can you apply here?
No, I'm not applying it. I'm saying that the court is applying a reverse issue or a reverse principle.
Therefore, in deployment also, Mr. Dotto, there may be a compromise.
Yes. May I say this, Miller? The Honorable Court does not say. The Honorable Court does not say. Please consider one thing. Today, my lord, I cannot argue before your lordship that I posted this person over there. I cannot argue because I have lost in the earlier round. Therefore, I have to argue that this person has been rightly deployed at that place. Therefore, your lordships have to consider whether he has been rightly deployed at a different place or not. Your lordships cannot consider today whether he has been rightly or wrongly posted at that place or not.
Very good.
Now the Honorable Single Judge is considering today what? Not the deployment. Today the Honorable Single Judge is not considering whether the deployment is in accordance with SOP or not, or the other principles. Today the Honorable Single Judge is considering, because my lord,
The posting is argued.
yes, because your lordships have not held that posting and deployment are synonymous. But I am making this submission, take it as a submission made 25 times, that deployment and posting are not synonymous. If they are not synonymous, then the guiding principles for posting cannot be applied in a case of deployment.
In deployment, if there has been a compromise, it cannot be interfered with. Suppose in deployment, taking cue from your argument, the deployment was made. In deployment also, had there been an arbitrariness, can the court...
My lord, all arbitrariness, my lord, springs from a right. Why this is black and not white, that cannot result in arbitrariness. Therefore, my lord, my respectful submission is that the principles applicable...
You cannot apply the principles of posting to deployment as has been upheld in the coordinate.
Earlier.
This is your...
Yes.
Next, anything
But the
else?
other aspect of the matter is, which is connected with the posting,
Yes.
once you say posting, the discretion is always with the employer, because an employer posts.
Yes.
Therefore, if it is held, irrespective of what 7A, what should be the interpretation of 7A, irrespective of that interpretation of 7A, all along, my lord, posting is a prerogative of the employer.
Yes. Yes.
Well, I have given my reasons. Right or wrong, I have given my reasons. Through the affidavit, which, my lord, the portions which I have placed. If this is not traversed, what is the result? But I can understand where there is a dispute. I say, I am right.
Mr. Dotto, you are the state. You will go by these technicalities.
No, it's not technical. It's a basic principle, my lord.
Principle is that
Miller,
your action itself is under challenge. You are justifying your action by saying that you have not traversed my argument. But You are the state, you are the model employer. Can you take this plea?
But again, your lordship is saying model employer.
Yes, you are a model employer,
No.
but
As a state, I have various functions.
no, you are.
I enter into contractual field. I construct roads. I appoint people. I provide education.
Now, one thing is whether you have the right to do so. That is one thing. And the next is how you exercise such right.
Right.
When you are exercising such right, it ultimately boils down to the issue that you are acting on the basis of the option exercised by a below ranked candidate in a particular manner.
Yes, Millard, number one is whether Millard I can do it or not. Number two, when I say I can do it because the SOP does not prevent me.
That you have argued.
Yes.
That you have.
And number two is he has to show that he has a right to be posted at the place chosen.
Irrespective of that, if the action appears to you have taken an action, suppose my brother is at rank 40, I am in a rank say below my brother, then you are calling my brother to exercise the option. You are accepting my brother's option. But in my case, you are not accepting.
Millard, could your lordship permit me to give an example without taking me amiss? Millard, in all courts, including our court, Millard, we have the judge's seniority. The point of discrimination, Millard, cannot come from a vacuum. It has to come from, Millard, some legally enforceable right. 7A does not say that posting must be as per the choice. It says counseling must be as per the merit.
Yes.
But I could have understood that 7A is challenged.
Yes.
Yes.
Anything else?
Yes. But let me finish this judgment. Then the state has compromised with the merit inasmuch as so-and-so in rank 26, so-and-so having rank 34 has been posted in the hospital opted by them at the time of counseling, so-and-so, so-and-so. The state has sought to interpret the phrase if offered to me appearing in the self-declaration of the petitioner to mean that it is the prerogative of the state to offer a seat unless the offer is made, the choice made in the counseling is not binding. This court is unable to accept such interpretation of the phrase as it would render the procedure prescribed under the SOP in the matter of deployment of the SR nugatory.
Observation 30.
Clause. Your lordships will not provide reasons for making an observation or rendering a finding.
Next line.
Kindly see, the logical interpretation of the phrase should be that the candidate must secure the merit position to get the offer according to his choice. The logical interpretation.
Yes.
The state has sought to justify the said deviation from the SOP also on the ground that the hospital where the petitioner has a higher requirement for an SR is the relevant discipline than the hospital opted by the petitioner. The justification is too feeble inasmuch as the deviation, if necessary, would start from the last ranked candidate. The Honorable Supreme Court in Asha Supra has held that higher the competition, greater is the duty on the part of the authorities concerned to act with utmost caution to ensure transparency and fairness. It is one of their primary obligations to see that a candidate of a higher merit is not denied seat. But I do not know how these principles apply. Educational principles will apply in the deployment or posting and say that the merit is compromised to the appropriate course and college as per his preference. So the principles applicable to the students in my respectful submission would have to be applied to the teachers as well.
Hmm.
Now kindly see, Millard, how Millard, the learned Judge Millard deals with the decision. The state has not disputed that it is bound to follow the principle laid down by the United States in the case of so and so, but has refused to apply the principle in the present case, alleging that the SOP, being an administrative instruction issued only to regulate the service of SRs during the bond period, lacks the force of law, even of a regulation, and as such not tenable. Pausing here for a moment, Millard. William Vincent is, Millard, a case of dismissal from service without following the rules.
Yes.
Well, in the first round, Millard, I have been shown the door saying that this is not a service matter. Please take the next line. The Constitution Bench of the Honorable Supreme Court in the case of Sukhdev Singh has held that even if the regulations have got the force of law, the principles laid down in Vincent should also govern the situation. But Sukhdev Singh again is a case of removal from service.
Hmm. Yes.
Then we have para 16. The SOP is a tool designed to achieve the right guaranteed under Article 14. Even if the SOP is an administrative instruction, the state is bound to follow the ethos of Article 14 to eliminate arbitrariness in the state action. In the case of Amarjit Singh Ahluwalia and Ramana Dayaram Sethi, the Honorable Supreme Court has laid down the principle that the nature of administrative instruction not having the force of law, but the state government could not at its own sweet will depart from it without rational justification. The said principle is equally applicable in the facts and circumstances of the present case. Where if your Lordship recollects Dayaram Sethi's case, there are two things. Number one is it was a case of tender. And number two, finally, Millard, no relief was granted. In Ramana Dayaram Sethi, where the Supreme Court finally, Millard, did not interfere with the process.
Yes.
Then kindly take me to para 17.
No, para 17, yes, Minhas.
Millard, B.S. Minas, again is a case of appointment. Appointment in ISI.
We have now para 18, your judgments have been
Yes.
taken. So, Mr. Dotto, you conclude your arguments then. You can summarize it.
No. I need to, Millard, this again, Millard, has to be noted. That my judgments are distinguished, saying that these are on so and so topic, therefore not applicable. But the judgments of the petitioner are not considered topic wise insofar as the applicability is concerned.
Yes.
Kindly similar to how my judgments are being now distinguished.
Very good. That is the procedure followed. We understood.
Yes.
Now, Mr. Dotto, you summarize your argument.
Yes. Now, just a minute. Give me permit to read the last paragraph. Conclusion.
Yes.
Summing up the discussion made above, this court holds that the decision of the state to deploy the petitioner at Raiganj clearly violates the Wednesbury principle. Thereby, the state has committed a serious wrong which demands intervention. Accordingly, the issue is answered in the affirmative. As a result, the impugned notification dated so and so and the list so far as the documents related to deployment of the petitioner are set aside. the department is directed to deploy and or engage the petitioner in the second vacancy, so and so.
Yes.
First submission is, Milord. Wednesbury principle was not argued.
Yes.
Second is, Wednesbury principle is gradually taking a backseat. Now it is the doctrine of proportionality. Milord, the learned Judge Milord has not applied the doctrine of proportionality or the corollary as to how disproportionate is the order.
Yes.
Therefore, principles not argued, Milord, has been applied in a judgment. But in all fairness, where the learned judge ought to have framed it as an issue and invited the parties to make submissions on it.
Okay.
Then, Milord, your Lordship may kindly take, Milord, the sheet anchor, that is para 7A. The learned Judge Milord has quoted 7A, applied 7A, came to the conclusion that 7A has been violated, but Milord does not render any finding as to which part of 7A I have violated, or which part I have made nugatory. But I have a submission. That submission can be negated, no doubt about that. But the submission that
there has been a violation. What is the violation?
Yes, but my submission was that choice is merit-based. I'm sorry, counseling is merit-based. Posting, deployment, engagement, everything has been confused, whatever it is.
It is the discretion of the state.
Yes, that is not merit-based. With respect, Milord, that point, Milord, has not been, Milord, dealt with by the learned single judge.
Yes. At para 13.
Yes.
All right.
Then, Milord, assuming that 7A confers any right, assuming so, Milord, it is directed in nature. There has to be some provision providing for the consequences of non-observance. Not
that you have argued.
Yes. But I'm just collating, Milord, my points. Just collating the points. But I'll request your Lordships to look into my written notes of arguments at page 127 of the stay application. But these are all points taken, Milord. I'll be this.
127. 127 is the.
Yes, I'm sorry. It starts at page. No. I'm so sorry, Milord. But I've noted out the wrong page number. I'm so sorry, Milord. Milord, it is 269. I'm so sorry. But whatever I have argued, my lord, these are all
That
points.
has been given here, 269.
These were filed, my lord, before the learned single judge.
All right.
Then my lord, the next point is, my lord, what is the effect of non-traverse?
That you must have taken in your. That we will seek his response.
And my lord, most importantly, my lord, what happens, my lord, if the court decides on by relying on judgments which are not cited or neither, my lord, the parties are called upon, but it often happens, my lord, your lordship finds that I have missed a judgment. After conclusion of hearing or during hearing, your lordships say that such and such judgment is there. We want you to address the court on the applicability or non-applicability of this judgment. But if this is not done, then what happens? But our High Court single bench, of course, my lord, has held, my lord, this is a procedure which infringes natural justice. Our High Court single bench, my lord, it has a persuasive value that relying upon a judgment without calling upon the litigants or the parties, court relying upon a judgment without calling upon the parties, my lord, to make their submissions on the judgment, infringes natural justice. Because after all, I am also a party, maybe the state. But your lordship may just have a look to, my lord, 2 lines of 1 paragraph. This is 2008 3 CHN 998, but this is an honorable single bench judgment.
Yes. Which paragraph?
Right, paragraph number 5, please take away the last 5 lines. Here, my lord, the learned judge, my lord, had taken note of a judgment which has come into effect post-hearing. Then the court says, natural justice not only means right to be heard and be represented, but also to provide an opportunity to deal with the judgment and or order relied by the tribunal or authority. Absence of opportunity to deal with the order as it has happened in the instant case makes the order valid.
Yes.
Well, we have also distinguished, my lord, please take note of, my lord, another written notes that we had filed. We are dealing with the judgments which my learned friend had cited, which is at page 277.
All right.
And my lord, though, my lord, I had said many things on malafide in my written notes, but since it has been given up,
he has not urged that.
Yes, but that, my lord, the learned judge, my lord, has noted. Just look into that sentence, my lord. Now, judgment as that. একদম শেষের দিকে আছে। It's at page 23 of the judgment. Last 2 lines. The petitioner has not made out a case of malafide, therefore the decision of the Supreme Court in the case of so-and-so has no application.
Yes, Mr.
But I have a very short submission. I got the written note that I filed, which is part of the record. I have not added anything. Only pages would be different because it was the pages from the writ petition itself. I just referred the pages from the stay in case there is a requirement. Well, first,
Give a copy to Mr.
that is part of the record itself.
Yes, even then.
Because this is with part of the record, only pagination is of writ petitions. Just to make it easier, in case there is a necessity, I gave the pages from the stay application. Well, first, what is the fundamental fact? Two aspects, which is not denied. My ranking is, there are 4 vacancies at RG Kar, not denied. So therefore, 4 persons can be there at RG Kar. No difficulty for that. My ranking is 24. There are 3 other persons, one above me, ranking number 13, and after me, that below my ranking 26 and 34, all got at RG Kar.
No, 3 others, 13, 26 and 34 got in RG Kar.
13 should get it because 13 is better than me.
13, 26, 34, there are 4 vacancies.
Yes.
And the other one?
Other one still vacant. That's the reason I said that you don't have to suffer anything. Even if you should have complied with your own SOP, I say that I don't want someone to pull down. Whatever you have done, whoever is below me, I don't mind. Let him be there. I say that your existing number of vacancies are 4. And I stand at number 2. Because my ranking is 24. I come just after 13. So you are allowing 2 persons who are after me. That's my fundamental point.
Was there any interim order? Not to fill up any.
No, there was.
It is still vacant.
It is still vacant. It's still vacant. Now, the other interesting part is total number of candidates were 871. This merit has been followed for all 869. Only 2. The other one who also filed the writ, that is his yet to be, because it was taken up first. I don't mind that state taking a stand that I have a right and therefore I can send anybody to anyone. I don't mind that.
This 871
is the total number of who passed. System is, it is not an recruitment. Because we have...
No, total was 871 in respect of how many it has been followed.
869. Excepting 2 filed writ petitions. 1 is already over. Other is, it is in the midst.
Which before the single judge?
Yes, before the single judge.
The same point is there.
There was a difference because in his case, he joined. And in my case, I sought leave from this honorable court and so therefore, he was not suffered because in my case, like, if I am at home for 1 month, just like we understand, my lord, last month we had a vacations. On the first day, in
the other case, he joined the...
He joined. Yes, that's the reason the honorable single bench thought that this is, it requires an expeditious hearing because this is the situations. My situation is this, my lord.
Which requires an expeditious hearing?
My case. Because of the reason
that you have not
because my role is only in the operation table. And if I am out of the operation table for 1 or 2 months, just like our profession, my lord, if someone is out of practice, my lord, I will lose my aid. I will lose so many things, which it is very difficult to come back to that stage. Now, kindly straight to, I think, so therefore, these are not disputed things. That number of vacancies 4, I stand at number 2 candidate, and number 3 and number 4 who are below me, they were accommodated following the same SOP. Now, this entire submissions of Learned Advocate General in one sentence is SOP for merit relevance is for counseling, not for engagement. This is factually incorrect. Kindly look at 7A quoted in paragraph 12.
Paragraph 12.
Paragraph 12, this SOP 7A has been quoted, so I'm referring for convenience. Paragraph 12 of the impugned judgment. That exact portion is at page 129, but Lordship may get it easily because it is quoted there.
Yes.
Kindly take, my lord, I will kindly read, my lord. 7A. Thereafter, the Directorate of Medical Education, along with concerned branch of the department, MERT, will arrange for engagement. Kindly pause. Will arrange for engagement of such candidates completing postgraduate degree at different medical college and hospitals teaching institutions of the state as SR for initial 1 year through counseling. Kindly mark the word through. For engagement through counseling. Now, how is based on the merit list prepared on the basis of? So, therefore, the entire counseling is for engagement. Counseling is not for anything other than for engagement. To say that counseling is for counseling, it only would take us that then for engagement, there is nothing. Then there would be no meaning of the word through. So arrangement for engagement so that, well, since this is not a recruitment, the number of candidates who study from all over India, this is one of the things they get to know at the time of admission, that after I complete for 5 years course, thereafter 1 year I have to serve. Now, why everyone, my lord, wants to be in a better colleges or a college where more number of complicated cases they would be able to deal with? Because they know if I am at RG Kor, then my exposure to the complicacy would be much more. I will learn much more. There are variety of disciplines which are not there in the states. Now, everyone will ask for it. Then how it has to be dealt with? That's a 7A. If you have a merit, then you can get it. Well, I don't say, I could have the interpretation of if what is the exact words? If allowed, if offered to me, that means, for an example, I opted for RG Kor, but I don't have the ranking required. Then of course it will not be allowed to me. That's Article 14. Nothing is required. Well, there has to be a mechanism. When this pool of 871 candidates, they know the number of vacancies. It's how it has to be done. If I read once more, paragraph 12, the 7A portion. If I read, my lord, by leaving unimportant words.
No, what did the court held to that? What is the court's observation to that?
Yes, my court's observation is paragraph 12 and 13 is this. First, paragraph 12, court held, this is 7A exactly. 7A exactly means this is will arrange for engagement and this has to be on merit. And then 13, court has addressed that you have deviated from the merit. Why and how? Because there are two other persons whose ranking were below the writ petitioners. You have accommodated them at RG Kor. Number one. And number two, you have done and followed the same SOP for all the 869 candidates. So therefore, to make out a story of discretion, now that doesn't have any.
Mr. Dhar, suppose merit is one thing,
Yes.
And exercise of choice is one thing.
Yes.
For counseling, you have to call on the basis of the merit.
Correct.
So I appear, I choose RG Kor.
Yes.
Another candidate who is next to me on merit.
Yes.
say he does not choose RG Kar, though it may be a better option, he
Correct.
chooses Raiganj.
Right.
So then if this crystallization of deployment on the basis of counseling strictly, as you are saying, is to be understood,
Yes.
then in respect of engagement, this does not come, which you are saying that this counseling mechanism is included within the mechanism towards engagement.
Well, why I say so? I have understood Lordship's.
Am I, I think, have I explained myself? Suppose you are hiring rank 2.
Yes.
You have been done this wrong according to you.
Yes.
Now I am next to you.
Yes.
Though I am entitled to RG Kar, I choose Raiganj.
Correct.
Now this engagement, if it is to follow the counseling, that state has no option to consider that whether on the basis of the counseling then he has to be placed, or we can exercise our own
No,
discretion.
madam, I have understood. I think, my lord, some factual thing as said by learned Advocate General, I need to clarify
No,
that.
Advocate General says that the term engagement is not qualified with this merit issue. This is a discretion of the state.
Yes.
Leaving about his other argument,
Correct,
whether
correct.
deployment or
Right,
posting, etc.
Yes.
He says
Yes.
that how can the candidate say,
Yes.
ask the state
Yes.
or compel the state to exercise discretion, since on merit he has been called for counseling and chosen RG Kar.
Malad, here lies the. May I have understood now. I have understood. May I start from the zero for this point? Malad, this is a brilliant submission. Now, this submission presupposes that merit is for counseling.
That is his call.
Yes. But that is not the fact.
Coupled with the issue,
That is not the fact. The counseling.
counseling is on the basis of
First, the counseling is an English word for a purpose.
right. Chose
Counseling, how we call it, that doesn't matter. Counseling is a mechanism. Now, if I put a question to myself, for what? Is counseling for counseling or counseling for something else?
No, counseling is a right given to the candidate to choose the vacancy.
Yes, to choose the vacancy.
Now, if the second candidate, his parental residence is in Uttar Dinajpur.
Yes.
Even if he is inclined to get RG Kar, he
Yes.
chooses Uttar Dinajpur.
Yes.
In that case, what the state is to do? If the state is to consider merit, then you cannot place that candidate at Uttar Dinajpur. You have to place it on the
No.
RG Kar.
May I say this? My lord, the counseling up to this part, my lord, there is no divergence. That counseling is a mechanism.
Yes. That
Now-
you have argued.
Yes.
There is a mechanism.
It's a mechanism.
of engagement.
Now, it's a mechanism for what? That answer, before giving any interpretation to that, if Lordship look at that, state has made at the SOP a mechanism. In the mechanism, two things they do. One is collection of the vacancies and declaration of them same. Like for RG Kar, there are phone number of vacancy. So therefore, transparently, it is known to all 871 persons. Now, out of 871, there may be 10 persons who are willing to opt for RG Kar.
Yes.
But state cannot give all this to 10. They have to restrict it to 4. Now, which 4? That's the point here, is which 4? I say that first 4. And when I say the first, I say based on merit. Why do I say so? Because of the words through counseling. Mala, this is not full stop. Through,
Continuation.
yes, through so counseling is a mechanism. Through counseling, based on merit list. What for? For engagement.
All right.
Mala, that give.
So your contention is that the mechanism which was followed in respect of 869 candidates was suddenly made topsy-turvy in case of one. And counseling is in fact included within engagement.
Yes.
Engagement is on the basis of the mechanism of counseling.
Yes.
What about non-traverse, your argument?
Yes, my lord, for long traverse, the fundamental. Kindly take my note.
No,
Because-
before that,
Yes.
Mr. Dotto argues that this observation interpretation has been nugatory. How the court said that? Page
My lord,
300.
yes, it is. Kindly look at this. I could have understood that the learned single judge has ignored this 7A. Now, once the learned single judge quotes the 7A, and when I say the fundamental words which are operating is the through and arrange for engagement, well, only interpretation is that the learned single judge has bodily lifted that what is the heart of the matter, and thereafter found that. Kindly look at the logic is, according to me, it was, my lord, kindly, may I read paragraph 13? Kindly start from, my lord, after 4 lines. So, first, entire 7A relevant portion, thereafter, from 4th line, in the present case, the state following the mandate of the SOP has posted 869. Here the word posted, in the conclusions, the word deployment has been used. Now, my lord, while giving dictations, I don't think we should give too much of importance to that, because ultimately in conclusions, the learned single judge has used the word deployment, though here the word has been posted. SOP has posted 869 out of 879 candidates in the hospitals.
Is you are applying the principles of posting to deployment.
No, it's not that.
That is his argument.
That is, in my understanding, that is a too hyper technical point. It is to say that just because Article 14 has been applied, if I give a metaphorical example, for a case of handicapped situations, as if only in case of handicapped situations Article 14 would be applicable. No. Article 14, if it is there, it can be there in the service matter, it can be there in the contract matter, it can be there in some other matters also. The heart of the matter is, has there been
Decision making.
yes, decision making process. This, kindly take paragraph 13, this portion, from 4th line, starting from just after the Bhavna theory, that quote. In the present case, the state following the mandate of the SOP has posted 869 out of total 871 candidates in the hospitals opted by them at the time of counseling, but such mandate has not been followed in posting the petitioner another candidate. And in doing so, the state has compromised the merit in as much as Dr. Such and Such, having merit rank 26 below me, and Dr. Tripanna Chattopadhyay.
Mr. Dotto says that compromise is a principle attachable to the issue of posting, not deployment.
Well, this is to say that. Well, this is. I don't think. But still, if I. So, my lord, learned Advocate General's point.
The answer is a general answer.
Yes.
That when there is arbitrariness,
Yes.
irrespective of deployment, service,
Yes,
anything
yes,
else, that has to be
yes.
done. This is your
Yeah, absolutely.
text. What is your argument on
Non-traverse. My lord, kindly take page 13 of my note.
page 13?
Yes. Well, the last bullet point.
Non-traverse.
Yes. Well, if I can just read the first this paragraph, some portion.
If you point bullets to the court, then the result will be otherwise.
Bullet. When without the word points, it becomes a bullet. But the moment the bullet and points, it becomes some exercise which is
Yes.
tedious for us.
Non-traverse.
But it is easier to understand. Well, this will be applicable only when burden is shifted and reply ought to have been filed. In the petitioner, all the contentions made fundamentally based on SOP, ranking being 24, total number of vacancy being 4, Out of 871 candidates, only deviation has been made for 2 candidates. In the affidavit in opposition, none of these fundamental facts have been disputed by the state. Therefore, I bank my case that this is, well, I have given up my case. I said that I don't need to argue on Malafide because I had one paragraph on that he was singled out because of the reasons that he was at the forefront in the quote and unquote RG Kar movement. But I said I don't require to make any statement on that. Why? Because to my understanding, my case was clearly covered by the state's own principles. I don't say that state, they don't have any right to change it. Tomorrow they might make for the bond candidates, they might say, instead of through based on counseling on merit, they might say also as per choice of the state. Then many candidates all over India, they'll think twice before coming to West Bengal hospitals. Today, what happens, my lord? When I enter into this admission, I get to know my entire structure. This is my course.
If a
Merit.
higher rank,
Hear me. Sorry.
if a higher ranked person opts for a lower rank or a lower hospital, he will necessarily have to take a higher rank hospital simply because he has a higher rank.
That is what we were asking.
Malad, there is, I've understood. Malad, I think there is no such thing higher rank hospital, and there is only a thing called higher rank in education.
Let's put it as
choice. Now the choice is a freedom.
So let's not get into the
no, I say the
academics of what.
No, I'm trying to say I may like to be at Medinipur. That could be my choice. Somebody's choice could be at RG Kar. But what I choose, state doesn't interfere. So choice is not defined. What's your choice? But your choice.
State can interfere.
If I don't have a merit.
No. What my brother is saying, suppose
Yes.
Rank number 2
Yes.
chooses RG Kar.
Yes.
I am the first rank holder.
Yes.
I also chose, or rather we can put it, the choice is made by the candidate. Suppose a lady candidate is there, his family resides at Uttar Dinajpur.
Yes.
Meritoriously, she will come within the fold of RG Kar.
Correct.
But she chooses Uttar Dinajpur.
Then she will get that. If she has the merit.
Right. So then choice overrides merit. That's
Yes.
exactly what I asked. You said no.
No. I said no because of the reason it doesn't override merit. It is based on merit. Kindly think twice.
It's not based on that.
No, it is based on merit because when that lady is asking for, kindly.
Are you saying that if I am higher in as a merit rank, then my choice gets
Yes,
over
not otherwise. It doesn't override. It's a prerequisite. To exercise my choice,
You have a right of precedence.
I have a right of precedence.
On the basis of merit.
Yes.
But Mr. Dotto says that if you saddle this engagement peremptorily with the choice exercise, you are interfering with the state's discretion. Because the
Yes.
clause says that engagement is irrespective. Engagement and merit has not been brought on the same fold. That discretion is left.
Well, to make that argument, what Mr. Dotto has made, a new SOP has to be framed because Lordship has only one SOP. What?
Yes.
Where my learned friend is harping on this choice, and he had said that if 10 people choose RG Kar, then the first 4 will get. Or
Yes.
the most meritorious 4 will
Yes.
get. First is where there is no scope of 10 people choosing RG Kar. Why? Because in the counseling notice itself, it is written that there are 4 vacancies only. Therefore, the moment the 4th person chooses RG Kar, there is no scope of any the 5th person to choose.
No,
That is why-
that's a technical thing.
Just-
One person might wish. It might wish. That's a
Now,
technical aspect.
state's discretion. Now, if your Lordship may kindly take me, Lord, page number 74. Let us just give an example.
Page
74.
72.
74. But this is the counseling list. Where towards the middle, Millard, your Lordship would find Millard RG Kar.
RG code. RG code. Yes. 4.
4. Now, if 10 people chooses Millard RG Kar, come to the last. Profullo Arambag MC. There are also 4 vacancies. Take an example, nobody has chosen at the end of the counseling, nobody has chosen Profullo. What happens? Can I not post anybody over there?
Mohammad Aziz, who is above me, he got it. Then 24, it's me.
13.
13, 1, 3.
13 got it.
13 got it. Because 13 is basically number 1. Then 24 is me. I am second. I have not got.
You have not got.
No, I have not got.
So you exercised RG code.
Of course, I exercised.
Now, who are the other?
Others are 26, Antora, and 34, Triponna.
আর কেউ opt করেনি RG করার জন্য?
আর তো 4টে ভ্যাকেন্সি তো খেয়ে গেছে, আর কেউ তো পাবে না।